In my session, I will really talk about the challenges of brand owners in protecting and enforcing the trademarks in the online environment. So that's really the focus on my presentation, just to clarify. And I think we can move on to the next slide. Thank you. So just to introduce myself, so you mentioned I'm part of the brand protection team at P&G, so Procter & Gamble. I'm based in Singapore, which is our regional HQ, so covering all Asia, Middle East, and Africa as well. And just to tell you a few words about P&G, so P&G is a global company in the fast-moving consumer goods industry. We have over 100,000 employees over the world with 65 core brands, so you can see a few there, centered on 10 product categories. So you may recognize some of them. So we have Gillette blades and razors, Head and Shoulders, shampoos such as Pantene as well, Ariel and Tide laundry detergents. So just to name a few. And we serve about 5 billion consumers in about 180 countries. So within the global brand protection team, we have about 30 people. And this is a multifunctional team. So we have lawyers, we have ex-law enforcement people, research and development personnel, as well as investigators. And needless to say that P&G takes counterfeiting and IP infringements very seriously. We monitor, so just to talk about online, we monitor the online environment, so meaning key e-commerce platforms, social media, sometimes as well independent websites, some apps as well, based on a strategic brand, country, platform combination. So this is more or less how we organize, how we structure the online monitoring. And with that, it allows us to remove about hundreds of thousands of online listings every year. So this is really like global numbers across global platforms and so social media and e-commerce. So the reason why we monitor the online environment is not only to protect the consumer and our brands, but also to help identify counterfeit sellers for further offline investigation. So really the idea is to identify viable targets to investigate and with the view of enforcing. And just to highlight that while I'm here to represent a consumer goods company, there is no industry, market, or product category, even geography, that is immune from the effects of counterfeits, but also IP infringements. And I just want to emphasize as well, I know there are many people on this conference, but that we are ready to work with anyone in the fight against counterfeits. Accordingly, I would like to thank IPKey, but also INTA, since we are here as an INTA member as well, for the opportunity provided to present today. So before we go into the more strategy, the more obstacles that we see into protecting and enforcing trademark and other IP rights online, I just want you to give you an illustration of what we are seeing today. I think it's interesting to know that in the past, and it's still something that we see, right? It's not completely forgotten, but it used to be very simple. The way that you protect, you monitor your trademark enforcement, your IP enforcement, looking at the way that your trademark was used. So very much bad faith use of your IP rights. It used to be quite simple to spot online. It has become much more challenging. So as you can see on the right side, the sellers are getting more sophisticated. They are getting smarter into blurring the way for us to identify the infringing listings. So consumers will see in many cases this kind of advertising. It doesn't mention any brands. It doesn't show any logo, any packaging. But at the end of the day, what they will receive is actually a counterfeit. So for just this illustration, Ariel laundry detergent, for instance. But to combat that, so P&G has a robust brand protection program that we have had for many years. And our strategies, as you can see, are very simple. So first of all, we attack and we frustrate the counterfeiter supply chain. And we aim to do so in a strategic, but also efficient and durable manner. So what we try to do is really to attack the counterfeit profit stream. And we focus our attention on finding and shutting down the manufacturing facilities if we can, and when we can identify. And when the manufacturing facility is unknown, despite investigation, the objective becomes to frustrate other elements of the counterfeiter's supply chain. So really striking at strategic points upstream, but also at points that are closer to consumers. So one of the very easy example, of course, will be to file a notice and takedown request to remove the listings so that consumers do not have access to this specific product. But just to say that this strategy that we have been applying offline for many, many years is exactly the same that we apply to e-business channels. So whether it's social media, whether it's e-commerce marketplaces. And so we do apply the same, whole supply chain concept. And what we really want to do is go beyond just filing the notice and takedown, which is just, like to clean the marketplace, but doesn't really resolve the problem. And to do that, well, we enable and we engage with third parties who can help us in this fight. I think one of the very good example is the MOUs, so the online MOUs. For instance, the one in the EU, the EU MOU PNG is a signatory of that, which has helped a lot in the discussions with the platforms, enabling real collaborations and trying to really raise the bar, especially when it comes to best practices on platforms. And more recently in Asian markets, so the example of the Philippine MOU, which is also a very good example of collaboration between the brand owners and the platforms. So the third pillar of the strategy is to make our products difficult to copy and counterfeits easier to detect via innovative solutions at product conception and design. And with that, we try to focus on the high-risk brands and high-risk countries that we determine through investigations and market surveys. So needless to say, you see a few numbers here, but needless to say that with the growth of e-commerce, which was accelerated during the pandemic, online sales have increased tremendously, and with that, the volume of counterfeits and other IP infringement cases as well. We see that as no turning back, even though in some of the markets, especially in more rural areas, we started to see a slight decrease, especially in this part of the world. Protection and enforcement of one trademark must be generated by the brand owner. So we start by ensuring that the trademark are registered in the jurisdiction of interest. This is the basis. But to be plenty effective, this is a combat that we need to take together with the online platforms and law enforcement. And just to comment on the numbers that you see on the slide, so in March 2021, UNIFAB, a French anti-counterfeiting association, reported the results of a study they conducted with 20 of their members. And in 2 months, these companies notified over 5 million of offers for counterfeits to online platforms. So basically, it gives you a ratio of about 82,000 infringing listings reported by day. And when purchasing in an online environment, all the more when purchasing on an online marketplace, consumers don't really know what is going to be in the parcel that they will receive the next day or the next week. And here, between the platforms and the consumers, trust is of the essence. Online counterfeit consumer products are often sold at the same price as genuine, and crazy online discounts may hide counterfeits, but they also hide scams and stolen goods. And talking about the photos, so how the sellers, they would advertise the products, they often use actually our own images, or it could be as well products of the genuine photos of the genuine products that they take into a store. So it's quite impossible for the consumers to know what it actually represents, what is actually true. And at the end of the day, so we are talking about trademark infringement, trademark enforcement, IP infringements. But I think it's also important to understand that when someone is selling fake products, IP infringing products, these also constitute a fraud. And basically, this will harm consumers. This will harm fair competition between retailers. And at the end of the day, this also harm the brand. Trading counterfeits online is currently very easy. On a marketplace, you can set up your own business in a few clicks, and you can frequently hide behind an alias. It's actually quite easy, even if you've been removed, to come back on the marketplaces. The sellers usually face less risk when they are selling online versus selling offline as well. And only if you get caught by the platforms, worst case scenario, your listings is removed or your e-shop is removed. Only few marketplaces, they efficiently prevent offers from actually getting back online. Very few actually suspend the trader's account after several incidents, and the policies, they vary a lot. It's not always transparent in terms of the way that they actually implement. Even fewer platforms, they will efficiently remove banned traders from re-registering on the platform itself. And currently, if efficiently banned from the platform, we can still start to sell on another platform. So there is no consistency across the platforms. So no matter what, as I've just mentioned, there is very low chances that you will face serious consequences. So then you will ask me what works, right? How do we actually, prevent that? How we actually make it more difficult for online sellers to sell infringing products online? So I think that's something we talk a lot into conferences, into exchanges, into panel discussions. So that's really about the collaboration. So everybody needs to play their part. So whether we are talking about the brand owners, online intermediaries, so the platforms, as well as law enforcement. But I see a part as well that the IP offices can play as well. And this has been proven true with the creation of MOUs, for instance, in the Philippines. And 5 areas where both collaboration and individual stakeholder action is required or is listed here on the slide. So I guess the first one is obviously detecting counterfeit offers and proving goods are counterfeits. This is an area where we need to collaborate because how platforms will know in the first place. Brands need to share their knowledge. Removing online offers, definitely. Sanctioning the traders, deterring repetition, and learning to prevent as well. So we can move on to the example of good practices from the brands. So for the brands, there are many ways, not supposed to be completely exhaustive, but it just tells you so what brand owners can do to play their part into fighting counterfeits online. So first of all, as I've just mentioned in P&G strategy, is really making sure that we go after the source. As is the only way we can actually prevent the fake products, the infringing products, from coming back into the marketplaces. So instead of just notifying online, where sometimes we do investigation to shut down the supply chain, starting with the online test purchase, and we try to eliminate and destroy the counterfeit inventory. If we can prosecute the large and repeat infringers, so offenders, and really that really helps to connect the dots. So this obviously, so for us to do investigations, to take enforcement offline with law enforcement, it needs that for the platforms to hold verified information to the retailer and somehow that they share with us so that we have access to that. Otherwise, we cannot do anything offline. We will just be stuck at the level of we report infringing listings online. And other good practices include utilizing the platform's dedicated portals to record IP rights, and also some specific information about the brands and our products as well. So it's good to know that actually based on that, some of the platforms they utilize the data that we share with them to do proactive monitoring and to prevent specific offers from coming back. And somehow for those platforms who have a more advanced artificial intelligence as a program, so AI, it helps to feed the algorithm on the platform as well. So this collaboration from the brand owner comes with the training and education of the platforms that I've just mentioned. And also something that is important as well is to listen to consumers. That's also very important to look at consumer reports. Most of the big companies like P&G has a consumer care line as well. So that also helps to identify some of the trends that we can discuss further with the platforms. Some good practices from the online platforms. I think most of all, the first one is really to make sure that we want sellers to be responsible and accountable for their action. I think that's really important and something that should be kind of the base for the platform's policies and so on. And this will not happen if the online platforms, they don't have a very solid and strict policy on IPR infringements, and also in the way that they enforce this policy. So for that, the clear terms of conditions are very essential for traders to play by the rules, and they also need to know the rules. So we've seen some of the platforms, they have very sophisticated education programs. They have videos that they develop in many languages as well to make it accessible to the maximum of sellers. Some platforms, they go further and they even ask traders for a financial deposit, and they will retain this deposit to compensate consumers exposed to counterfeits. So others, they will find traders for any counterfeits found as well. So this is kind of the next level. And only a few platforms that has the problem will proactively detect counterfeits. This can take various forms, so from monitoring details of offers posted to conducting fully fledged test purchase programs. Really depends on the sophistication of the platforms. And the effect of the notices, so the notice of takedown, can be very different from one platform to the next. So someone will just remove the offer notified, some will preventively suspend all offers of a trader for a product or a specific brand while investigating further. If a trader utilizes several online trading accounts, some platforms will connect the dots and will issue sanctions across all connected accounts. Some platforms also have dedicated resources to actually look into these problems, and some don't as well. So it's also quite difficult to establish standardized best practices across the platforms. You also need to look at which level are the platforms at the moment. So, but all in all, so it just comes back to cooperation. I think that's really the key message here. It takes all of us to protect consumers, to protect the retailers, and to protect the brands as well. Brand monitoring is good. So what we are doing, what some of the online platforms are doing is good, but it's not sufficient. And we believe that marketplaces have a significant role to play here. They have better tools than us to screen their own content and to screen the sellers. And they have full visibility on the trader's history and trading patterns. So how many consumers complained, turnover of the sales, and other important data about the sellers. Law enforcement monitoring, on the other side, has potential to bring an immense added value. For instance, we have unprecedented experience with some European law enforcement who are proactively searching an online marketplace for counterfeit laundry products and matching sellers' publicly available details with customs, import, or export data. And this has led in the past to uncovering a whole counterfeit distribution network. On verification, brands obviously have a significant role to play in verifying authenticity of the goods. We talked about that, but this does not always require verification of offers one by one. A number of verification can be automated through brand and platform cooperation. For example, counterfeiters keep inventing new variants of our products that we don't make and will never make. With the right data from brands, the platforms do not need to verify each time with the brands what we don't make and what we do make. Some are quite very obvious. So one example we've seen in the past was actually shampoo with a garlic flavor is something that P&G will actually never make. And also, I think for us, what is important as well is understanding whether a target, a seller is worth pursuing through offline investigation and enforcement. We have very limited data on the sellers, and what we find actually useful when we collaborate with the platforms is at least to get this kind of thumbs up, thumbs down approach, where the platforms will at least just let us know, is this a viable target or not? There's something that is very important to the brand, because otherwise, how do we know how to prioritize further offline investigation and enforcement? And obviously, this is only when the full picture comes together that we can respond to incidents in an appropriate manner. So sometimes, some sellers will just justify a warning or a cease and desist letter. sometimes because of the turnover, the inventory, and the large business that they might hide, a right action might be more appropriate and working with law enforcement. So despite all of these efforts that we are putting together, so between brand owners, these best practices from the online platforms and trying to connect the dots with law enforcement, we still see some opportunities. I think that the first one is really on the legislation and the frameworks, really supporting our common goal. There are numerous areas where modernizing the legislation and designing new solutions is required to fight better counterfeits in an online environment. And just to take an example, currently we see that legal or practical barriers to data and information sharing are getting into the way of affecting consumer protection. So as I've just mentioned, when we don't know enough in order to proceed with investigation within enforcement. And this is true, in other areas as well. Today, in many jurisdictions, when a platform suspends a trader's account following numerous notices of infringement, the information stays with the platform. They cannot proactively share it with law enforcement or judicial authorities until we get a court order. They cannot proactively share it with other platforms, and they cannot tell a brand a trader was suspended following multiple notices from other brands. Basically, they cannot proactively tell us which counterfeit volumes were traded prior to the suspension. So just to say that brand owners have very limited information, and it doesn't really help us in the way that we prioritize our strategy online, but also somehow impacting the offline program. So we believe this gap needs to be addressed either through legislation or through alternative solutions. Also, another opportunity, which is more in the technology area. So technology moves very quickly. Platforms and right holders work together to improve their collaborative efforts. We've mentioned that to protect consumers. But we see that bad actors, they will just move to other platforms that are less proactive in protecting consumers. So this is just the reality that we see. And this is typically true for emerging platforms who have less experience with illicit activity. So there is a need to evolve with emerging trends as well. For example, community buy is a business model in China that allows users to purchase products at discounted prices through group buying based on the idea of collective bargaining. So this model has recently become popular with counterfeiters to sell fake goods. And this is quite often an area where so the platforms are connected to both social media and messaging apps, making it very difficult for the right holders to track and remove the fake products as well. Another example of emerging trends is messaging apps such as WhatsApp, Signal, Telegram, Viber, so whatever is popular depending on the markets, which are becoming increasingly popular. These apps provide users with a secure, encrypted means of communication. And with that, it makes it very difficult for the brand owners and law enforcement to track and intercept counterfeit activity. And the last opportunity, there are, of course, a lot more, is into raising awareness to consumers. But also how to do, retailer education. Because we believe both are really essential in the way that we address counterfeit problems. It's true online, but it's also true offline. And what we see as well is that some consumers knowingly buy counterfeits for a variety of reasons. It could be from a price to believe it's actually not a big deal. So this is a victimless crime, and they will not be, fined or sanctioned for that. So most of the counterfeits of the consumers, don't even know that they are buying counterfeits. We believe that effective education helps consumers, but also retailers to understand the health and safety risk associated with counterfeits. It's very true, for instance, for P&G products. We were talking about personal care products. We also selling toothbrush, toothpaste, and so on. And it helped them to identify steps they can take to avoid purchasing and selling them. So here as well, we believe that all stakeholders have a role to play into raising awareness and education. This is essential to decrease the demand for counterfeits, and somehow we can all contribute to this. Very likely, some retailers will continue not caring if they sell counterfeits or genuine products as long as they sell. But this level of carelessness is fueled by a sentiment of impunity when trading online. So this is even more important, and another reason why we need to be more strict and play a collaborative role when it comes to online infringements. So just to highlight as a last comment that all stakeholders, so brand owners, platforms, but also law enforcement and government agencies, if I want to take it further, have to play a role in demonstrating impunity doesn't exist and in holding counterfeit traders accountable for the consequences of their actions. I think that's really a key message for us. And on that note, so I will end my presentation and just open the floor to any questions they may have. Thank you very much.
Thank you. Thank you very much, Laure. Just a question on the MOU. Um, can you please explain further what it is? And you mentioned that there's an existing MOU with the Philippines. Is there a plan for you to enter into more MOUs in other countries in the region?
Absolutely. So for those who are not familiar, these online MOUs, which are targeting online counterfeiting, but also online IP infringing products, piracy as well. So the whole idea started in the EU a while ago, and this document is mostly between signatories are mostly brand owners like P&G and platforms, online platforms. In the EU is a little bit wider, so you get a mix of e-commerce platforms, but also social media, so it's a bit larger. And the idea is to create this level of collaboration so we can and really to raise the bar when it comes into best practices for the online platforms. So really the brand owners and the platforms kind of working together into raising the bar, making it more difficult for the online sellers to sell counterfeits. And although it's not mandatory, it comes with some KPIs, so some objectives, both for the brand owners and the platforms that help to also measure success of such a MOU. I mean, just to very quickly explain how it works. But basically, the main benefit that we see for brand owners is that it opened the door for communication with the platform. Suddenly, we have a forum to express our concerns, share our trends, also provide them education on our brands, the main targeted products by infringers. And for the platforms, it's kind of push them to to follow what others are doing and to think about better practices as well, to in their know your customer policies, in the way that they look at repeat infringements and notice and takedown as well. So this was first implemented in the EU, and about 2 years ago, so Philippines implemented as well a MOU, which is quite similar in nature. So far, in terms of platforms, 4 have signed: Shopee, Lazada, Zalora, and more recently TikTok. And quite many brand owners have joined it as well. And I guess here as well, the first benefit from the brand owners is really to have this level of collaboration, suddenly find a contact within the platforms, which might be the major pain point for many brand owners. Who do I talk to, if I have a problem online? Who can help me to speed up my complaints? Where do I go if I want to investigate further one of the targets? So that's really one of the key benefits. And for the platform as well, somehow, because we share as well, platforms share about what they are doing. The brand owners also share about their pain points and the wish list somehow. I think it helps them as well to understand what's really the problem that the brand owners are facing and how we can actually improve in the future. So that's in the Philippines. In the region, I know there are some discussions as well about other MOUs. So I guess for as P&G, we're just waiting to see what's coming next. But obviously, that's something we might consider to join in other markets as well. Just waiting for what is coming next, I guess.
Thank you very much. We have no questions, no further questions at this time, but maybe some of the participants may wish to ask questions for later after Nick's presentation. Thank you very much, Laure.
Thank you. Thank you.
Okay.
I am the enforcement head at Rouse, an IP firm. I'm based in Indonesia. I've lived in Southeast Asia and China for the last 25 years. So I hope I've got a bit of regional perspective to bring. I also sit on INTA's Asia Bad Faith Task Force. So this presentation is something that INTA gives regularly in different forms, particularly around Southeast Asia, but also beyond in other countries in Asia. So the background is that bad faith trademark filings have become an issue in many different countries. Essentially, the digital environment makes all brands very visible. Even a new brand launching in one country can be seen on the other side of the world now. And that gives an advantage to pirates who are looking to register other people's brands. So this has become a priority focus for INTA. They have an enforcement committee, and that created a special task force 5 years ago. Over recent years, we conducted a survey in over 90 jurisdictions, and that led to an inter-board resolution on bad faith in 2020. So what did the survey tell us? Well, most countries do recognize this as a problem. So this is not something that is new in most places. It's something that's already a problem or have been identified as a potential problem. However, many laws do not provide the option of rejecting a bad faith application during the trademark examination phase. Or potentially there's a high evidentiary burden that means that it's quite easy for a bad faith application to pass through examination. So that's the first point. And we'll talk a bit about the relevance of the examination phase a bit later. The second takeaway, or third takeaway, is that bad faith is not always, or it can be quite difficult to raise it in opposition or cancellation. Some countries do allow it, but not always both. So you might be able to raise it in a cancellation, but you're not able to raise it in opposition. Or there are some challenges at doing that, particularly around burdensome evidence to support bad faith claims. So there are a number of challenges that trademark offices face. Usually they're hindered by the laws or the regulations that they have. It's not that they don't understand the problem or know how to deal with it. They might not have the tools to actually take action. So that conclusion meant that INTA decided to take a formal position on this, and that is how the board resolution came about. So what is the board resolution? Well, what INTA's board resolution tried to do is to set out some best practices. What should trademark laws say? What should trademark regulations enable? And what should trademark offices do around the world? So the first point is that INTA hopes that bad faith is a standalone ground for refusal, including ex officio by an examiner during the examination of a trademark. That is basically the most efficient place that a decision can be made. It prevents the long and time-consuming proceedings that may then follow if a mark is not rejected for bad faith at that phase. Secondly, there needs to be a separate separate and explicit ground for opposition and invalidation or cancellation. So that is to say that an opponent can actually raise bad faith and place that in argument with evidence if necessary at the opposition phase or later on at the invalidation or cancellation phase, which usually comes much later on. So essentially, there need to be 3 phases for bad faith refusals. And the third thing is that the burden of proof may shift in certain circumstances where there's really obvious bad faith. For example, a whole series of copies of a famous trademark. At that point, it's really upon the applicant to prove good faith. And that's where the examination phase can essentially offer a rejection unless the applicant can prove good faith. So that's the third one. The fourth is to actually maintain some records on bad faith filers, because one of the things that is quite common is that bad faith filings are often done in sequences or in batches. So you quite often see someone file a whole array of of well-known or other brand new trademarks as bad faith applications, all in one go or over a period of time. So if records are kept by the IP office, then it becomes obvious that that person's filing in bad faith. And number 5, there need to be some kind of penalties, damages awards or fines or both. To it or costs will be another option to prevent this happening again and again. Why is that? Because, as I say, it's quite common for one bad faith filer to file many trademarks in bad faith or to target multiple brands. Now, the first thing that a trademark office will say is, well, how do we know that something is in bad faith? And this is where the second part of the board resolution comes in, which is that it provides an illustrative list of factors to be considered when assessing bad faith. So some of the things that a trademark office could look at is, have they previously been identified as a bad faith filer? Is there a prior relationship with the legitimate rights holder? Something like that might come up in opposition, where you find it's a former distributor or former agent that's filing the trademark in bad faith. Another might be they've offered to sell the mark at a high elevated price. Again, that might come up in an opposition or an invalidation. It might not be obvious to an examiner, but where there are identical or highly similar marks, especially when you see logos being copied, that's much more evident to an examiner. The rightful owner has other relevant trademark rights. You can see those, a famous mark in a different class where the logo's also been copied. Well, it's very obviously going to be a bad faith application, even if it's in a different class. Patterns of bad behavior. I mentioned multiple different brand owner squatting cases or multiple different classes. Again, that will be an example of one of the factors. Indiscriminate coverage that's obviously incompatible with honest interests. So filing a whole series of different classes that are unconnected might be an example of that. Multiple filings of various different versions of a mark. And nuisance filings is another example, or lack of genuine business activity, or lack of bona fide intent to use, where you've done a search on the internet and you can see that this applicant really isn't engaged in this business at all. Now, these are illustrative factors, and I'd like to just refer to something completely different. The way to think about this is to think in the same way as the WIPO recommendation on well-known mark factors. No single factor gives you the answer. Maybe it's a combination of them, and maybe it's none of them. It's something different. But you look at them as a non-exhaustive list of factors that helps you make a decision based on looking at all of them. So why did INTA come up with this? Well, the rationale is that it's far better to address bad faith at the examination or prosecution level. It's really far cheaper because then you're looking at an early phase in the proceedings. Or even if you're dealing with oppositions, that's often much better because you're dealing with administrative proceedings, and that can be much cheaper than going to court. It's less costly, it's less time intensive, and I want to look at that from several perspectives. The time and the costs on the part of the IP owner is one thing, but also clogging up trademark office time with bad faith cases is really not very valuable. It's using up government resources, it's wasting government money and taxpayer money, it's using up examiner time on cases which really shouldn't be there in the first place because they are not honest, valid trademark applications. So preventing those initial registrations is therefore really important. It also acts as a deterrent. You can see the countries where bad faith is well policed and oppositions and examinations are effective. Countries which have extensive bad faith problems are usually quite well known, and that's where the laws are extremely narrow, or the trademark office is not allowed, except its examiners do not have the powers to decide things based on bad faith. Of course, office actions and cancellations are a second option, but of course many countries don't go that far, and they insist that you go to court. And that really is putting a huge burden on the opposition, sorry, on the opponent, on the trademark owner, the genuine trademark owner. And again, it's clogging up the courts with cases that are really they're not valid IP rights. They're essentially rights that are almost always, and if you look at cancellation cases in courts, they generally always are won. It's an enormous waste of everyone's time if the cases go to court. And it's absolutely critical that if they do, that there are damages and fines. There are countries which have cancellation cases in courts where there are no damages and no fines, and all that does is make most of the cases about cancellations and just occupies the courts on cases that the IP owners almost always win, but they're incredibly expensive and time consuming and difficult, and essentially make that country a very expensive place to do trademark business. And frankly, in most cases, it's the consumers in those countries that have to pay through the higher costs of goods for the budgets that IP holders have to spend and the taxes that they spend on maintaining courts to run these cases. So that's INTA's rationale. That's the reason that INTA's gone through this quite time-consuming process to do the survey, to create the resolution and all of the content. And the resolution is available online, and any IP office can download that from INTA's website and have access to those factors to have a look at them, to help look at bad faith cases. So let me have a look at some case studies just to give you a flavor of some of these. This one is a case from the UK, actually, where I first started my career. This is a case where an individual filed hundreds and hundreds of trademarks through a series of companies. So it was actually something that was known about. And in fact, the case was appealed, which is why I did actually end up going through several layers of appeal from the trademark office. And the applicant, Mr. Gleisner, had filed something called Trump TV. It was filed in 2016. And as I say, he had a network of companies. He tried to file various different versions of individuals' names. And this was one of them. 2016, you may recall, is when Donald Trump was first elected to the US presidency. So you could see the timing was very, very deliberate. And as a result of that, the IP office decided that the application was in bad faith because it was highly improbable that there was a bona fide intention to use that mark. In fact, it was more likely he was going to interfere with the legitimate business interests of Donald Trump's business. So that was a fairly obvious case. And as a result of that, bad faith was proven, and the IP office awarded the entire amount of the cost or the legal fees of the UK attorney who'd filed the case. I think it was about £15,000. And although probably they spent more than that because it went on appeal, you don't recover all of your costs sometimes in the UK, but they felt that £15,000 was enough of a deterrent to prevent future bad faith applicants. That's a UK case. The next case is a Canadian case, and this one is an interesting one. This is a bit more recent. The logo at the bottom is actually a Chinese trademark of a Beijing restaurant. And in Canada, an individual who was in some way Chinese, had a Chinese name anyway, and I guess potentially had some background in China or Hong Kong. And I'm not clear exactly where this person was from, but it was clearly a Chinese name in the name of the applicant. And this was a well-known Beijing restaurant incorporating Chinese characters, which you can see in there in a stylized format. And that restaurant was apparently quite well known in Beijing. And a number of key factors were that there were messages to potential purchasers offering the mark for sale. So there was an offer for sale of this mark. It seemed like it was in bad faith. It was such a unique logo that since it incorporated the characters, the logo and so on, it seemed to be fairly implausible that they could have created this design independently. So the hearing officer inferred that this was almost certainly an attempt by somebody who knew or wanted to claim some benefit from the Beijing restaurant. So that was the way that the court found, or the hearing officer found intent, and also the pattern of similar activity. There were a number of other filings by the same person for other trademarks that looked like other Chinese restaurants. It's quite common in these cases that the applicant doesn't do anything. And in this case, no evidence was filed to rebut that. So that was the kind of obvious situation where the facts really pointed to that being a bad faith. No damages were awarded, but I believe costs were awarded at the end. Costs were awarded at the end of that. So that shows, in fact, that there are specific legal reasons why damages couldn't be awarded in that case, but costs could be. So that's the importance of showing why legal cost recovery is an important thing to have available as a tool. This case is a cancellation case from Indonesia. I'm sure many of you will be familiar with the trademark Bloomingdale. It's the well-known department store in New York. This one, maybe you could say, is a bit more obvious because this is quite a well-known trademark. So there were already prior trademark registrations, but the defendants filed in slightly different classes than Bloomingdale's had filed in. So there was definitely similarity, but not identical. And there were definitely some connections across classes, but not necessarily identical. But of course, you can infer, if you looked at the logo, that there was an identicality in relation to the font. So that was one where it should have been fairly obvious that that was a bad faith case. However, of course, no damages and no costs. So it would have cost Bloomingdale a lot of money to bring litigation, because in Indonesia, these cases have to go to court. So that's an example of where, yes, there's a solution, but an extremely expensive one and very time consuming. And frankly, yeah, it should never have gone all the way to the courts, really. In an ideal world, that could have been solved at the trademark office. So this is some of the data from the survey work that we've done. Just looking at Southeast Asian countries, there are several patterns. There are countries where bad faith is allowed to be considered in examination, oppositions, or court. Indonesia is one, although it's not so commonly done in examination. Vietnam has recently amended its law, but the guidance is not yet out. So that's one where that's quite important to see what happens going forward. Philippines allows it across the board. Malaysia and Thailand are in a slightly different situation. And I'll give an example about how that works in Malaysia in a moment. Singapore does have all of the options. So let's talk about Malaysia. And Thailand is very similar to this, not in the exact same provisions, but basically bad faith is not grounds for rejection at the prosecution stage. So that means that the IP office in Malaysia, My IPO, cannot actually reject purely on the basis of bad faith. And the same for oppositions. However, there is an expungement ground to bring suits by the court. So a form of invalidation is not actually bad faith, though. What it is, it doesn't mention bad faith, but there's some kind of ground relating to prior rights or fraud, which has been interpreted to include bad faith. So this is an example about how bad faith is so important that the court had to find a way to get around the gap in the law. So that's essentially what's happened in Malaysia. And obviously that's not ideal. And it means that the courts have to spend a lot of time on bad faith cases. They're expensive, time consuming. An applicant may recover. There are provisions for damages and costs in Malaysia, but of course it's risky to go to litigation. So not an ideal solution. And Thailand has a broadly similar position that bad faith is not a ground for rejection at the prosecution and opposition stage. So having said all of that, there is a lot of work going on across the region. So improvements are being made all the time. And as you can see, Indonesia is an example of a country where bad faith cases can be brought. Vietnam what INTA hopes to do is to work with IP Vietnam on the new circular under its new IP law, which actually expressly mentions bad faith for the first time. So that's a positive development, and the implementing guidelines hopefully will come out at some point. In the Philippines, we've already had engagement with IPO Phil, and there was some bad faith training last year. So we hope to engage more with IPO Phil in future years on that. And we're exploring the possibility of doing something similar, having done training in the Philippines and recently in Malaysia. We'd like to do something in Indonesia. In Thailand, we'd like to set up some engagement with the IPD to talk about bad faith. And then in Malaysia, we recently, as I say, had some training with my IPOs and the courts as well. So we'd like to follow up on that. So that just gives you a bit of a flavor for the issue across the Southeast Asian region and the work that INTA's doing to try and deal with the issue of bad faith. And hopefully, over time, we can start to have a stronger impact and prevent these applications that essentially clog up unnecessary court cases, unnecessary cancellations, invalidations, opposition, and support IP offices to enable them to catch them as early as possible. So thank you very much. I hope that was useful, and I'm happy to take any questions or comments.
Thank you very much, Nick. Well, we had one question earlier on the different countries where where bad faith is used as a standalone ground for refusal, but you've already presented a very nice table showing which countries have bad faith at the level of examination, etc. So, but bad faith is still a continuing problem in Southeast Asia. So, in addition to the survey that you did, and also the INTA initiative, are there other initiatives that that are planned together with IP offices to curb bad faith applications or registrations?
Yes, I mean, there are some countries where, I don't know the underlying reasons, but there are certain countries where it is a more significant problem than others. So, it's very well known that China has a very significant bad faith trademark squatting problem. Many people will be aware of that. In Southeast Asia, it's not as commonly found, but we do see cases in Indonesia, in Malaysia, in Philippines, in Thailand. So there have been cases in almost every country. So I think it's something that there will be an ongoing engagement. And I know that the enforcement committee it actually comes to the end of its term this December, but I'm sure it will renew its activities next year. And I hope a number of those engagements will continue into the coming years, because this has been addressed, INTA feels this is serious enough for it to be dealt with by its board of directors. So it's a serious enough problem that IP owners have felt it necessary that this has to be dealt with at the very, very highest level at INTA. And that's why the INTA board resolution sets out so much detail on this issue.